हमारे संविधान के किसी भी आर्टिकल को, if you really want to understand that, we have to look firstly at the preamble. The essential character of Part 3 is that it is a restriction on state's power. State does not have the power, that's what Article 13 says. An uncontrolled right would mean that you can say, preach, and express anything that may be absolutely anti-national also. The economics of it is very important, but Supreme Court is not equipped to handle. Called for the expert opinion hasn't been implemented. We don't know what is that expert opinion. You have a right, but then you have a balanced right. It's not that you can just say about anything, do about anything. No.
The New Indians presents Law and Justice by Vedic Legal in association with Vedic Legal and Company and the Senate of Jurists.
नमस्कार, मैं हूं ऐश्वर्या बख्शी और आप देख रहे हैं द न्यू इंडियंस। और आज हम बात करने जा रहे हैं कॉन्स्टिट्यूशन के दो बहुत ही मेजर आर्टिकल्स के ऊपर, जो कि है आर्टिकल 19 और आर्टिकल 21। और इसी पे बात करने के लिए आज हमारे साथ मौजूद है देश की एक जानी मानी हस्ती, सुप्रीम कोर्ट के सीनियर एडवोकेट मिस्टर दिनेश द्विवेदी। सर, बहुत बहुत स्वागत है आपका।
थैंक यू
सर। जैसे मैंने बताया कि अभी हम आर्टिकल 19 पे डिस्कशन करेंगे, तो सर आर्टिकल 19 जुडिशरी आर्टिकल 19 में रीजनेबल रिस्ट्रिक्शंस को कैसे डिफाइन करती है?
देखिए, इसके पहले कि मैं आपको ये बताऊं, कुछ चीज़ें आपको समझनी पड़ेगी ग्राउंड लेवल पे जो है
जी।
हमारे संविधान के किसी भी आर्टिकल को, इफ यू रियली वांट टू अंडरस्टैंड दैट, वी हैव टू लुक फर्स्टली एट द preamble, which provides for certain objectives of the Constitution, like social justice, equality, fraternity, broadly, and including religious tolerance. Now, having seen the preamble, we go into the part 3 of the Constitution, which contains fundamental rights. There, Article 13 is very important, which prohibits the state from making any law or doing anything that interdicts or restricts the fundamental right. Rights guaranteed in Part 3. These are fundamental rights. Now, Article 14, 15, 16, a set of articles where equality aspect is emphasized, including religious tolerance and secularism. Then comes Article 19. I'm omitting 17 and 18 because they're not relevant for our purpose at the moment. 19 is an article which is what I would say certainly an epitome of our freedom struggle. As the nation controlled by the British, we didn't have fundamental rights, that is, right to speech, expression. Those were absolutely controlled and guided. Then right to carry on any profession, trade or calling, the mobility rights, etc. They were all controlled. Now, once the essential character of Part 3 is that it is a restriction on state's power. State does not have the power, that's what Article 13 says. And if state does not have power, then obviously what would have happened is that there would have been an absolute license for saying whatever you want to, expressing whatever you want to, doing whatever you want to. So therefore, the framers, who were wise men of course, they thought that there should be some enabling power in the state to control the unlicensed kind of an exercise of right. So therefore, they brought in the term reasonable restriction. Clause 2 to Clause 6 of Article 19, they enable the state to impose restrictions on various grounds, but most of the grounds are like
बट सर, ये इंडिविजुअल फ्रीडम को पब्लिक ऑर्डर, मोरालिटी एंड नेशनल सिक्योरिटी के साथ कैसे बैलेंस करता है?
देखिए, national security is a separate issue, but वो करेगा balance. For instance, if we have a right of speech and expression, the unlicensed and uncontrolled right would mean that you can say, preach, and express anything that may be absolutely anti-national also.
So there should be a line between a permissible criticism and a hate speech.
It will always be. There has to be a balance. And reasonable restriction concept does at the very inception specifies that you have a right, but then you have a balanced right. It's not that you can just say about anything, do about anything. No. You have to be in a balanced manner. You have to speak balanced manner. You have to express balanced manner. I mean, you have to do things that are legitimate, legal, traditionally regarded as legal. Not legally, but not under statute, but traditionally regarded as legal. So this is how it tends to protect the balance and effect the balance, because it has to be in public interest, security of state, national interest is the highest public interest that there can be, and so on and so forth. There are various kind of items specified there, which taking advantage of which the state can impose reasonable restrictions. But the term is reasonable restriction. It is a restriction, no doubt, but it has to be reasonable. So the test of non-arbitrariness also comes in. That reasonableness means that it can't be excessive. For instance, take the case of occupation. So I have a right to carry on business. But state can impose reasonable restrictions. For instance, I cannot carry on business in human trafficking, or perhaps bomb making or pistol making, anything like that. So a restriction can be imposed, but it has to be a reasonable one. For instance, gun licensing is there, so you can carry on a business within the framework of the licensing. But the licensing should not be such that would completely oust the business. For instance, if any business, the licensing is so terse and so arbitrary that you can't carry on business, that it is more of a restriction, but it is, to say correctly, it's a restriction which prohibits business. That is not, you can regulate, but you can't prohibit.
Sir, it's a very famous landmark case, just Shreya Singhal versus Union of India. So, इसमें reasonable restrictions को कैसे बताया रखा है? आप एक बार audience को बता सके तो.
देखिए, श्रेया सिंघल का आप जो नाम ले रहे हैं, normally I can't recall the entire facts of this case.
Okay.
If you can put in the facts, and I can explain what was the restriction, why was it done.
If you can.
But there is, excluding these exclusive cases, but the fact remains that by and large the principle is the restriction has to be non-arbitrary and reasonable, so that a person can conveniently carry on the legitimate trade, traditionally legitimate trade or business. Likewise, in speech and expression, you can carry on your speech and expression rights so long as you don't become abusive or you don't affect national interest or public order. That's a very big factor. Inciting communal violence. If it is not restricted, you can do that. So that's where restrictions do come in to balance the right and the power of the state.
So, जो शाहीन बाग प्रोटेस्ट है, फार्मर्स का जो एक पीसफुल प्रोटेस्ट वो डिमांड कर रहे हैं, गवर्नमेंट उस पर बात क्यों नहीं कर, उस पर मतलब लाइक उन्हें फिर इसे रेस्ट्रिक्शंस में क्यों रखे जा रहे हैं? उनकी भी तो एक तरीके से उनका पर्सनल लाइफ, पर्सनल लिबर्टी वाला एक तरीके से एक चीज़ हार्म ही हो रही है ना सर?
देखिए, आप शाहीन बाग की जो बात कर रही हैं और फार्मर्स प्रोटेस्ट की बात कर रही हैं, so the issue is there is a legislative power. Under our constitution, the executive power is equal to the legislative power.
Right.
So whatever jurisdiction is given to the legislature, to the union or to the state, they have the equal executive power. In the event there is no law, they can exercise the power. Again, reasonable restriction will apply. Now, I do subscribe to the view that in the case of Shaheen Bagh, the observations that had come from the government side they were unjustified. I do subscribe to the view that some of the actions taken were a little ruthless and it should not have been taken.
ये सुप्रीम कोर्ट का क्या है मतलब लाइक इस पे अप्रोच है जो फार्मर्स प्रोटेस्ट जो वो डिमांड कर रहे हैं कि हमें पीसफुल प्रोटेस्ट करने दिया जाए?
That was a mishit kind of a thing, I would say. I mean, farmers' protest is an issue which is so huge and wide and affects the economy. The economics of it is very important, which Supreme Court is not equipped to handle. Supreme Court, in my view, had unnecessarily intervened in the matter. And that is why you see they called for the expert opinion. The expert opinion hasn't been implemented. We don't know what is that expert opinion. Because eventually it seems to have dawned on Supreme Court that perhaps it's not a matter where they can intervene. A very huge chunk of population is clamoring for something. And government has its own views and sides. So it's not for the Supreme Court to intervene in this matter. They shouldn't have intervened. And what can possibly they do? I mean, the agitation primarily, if you recall, was against the 3 farm laws. Now, the validity of the 3 farm laws was in question but has not been answered. So either they should have answered the issue of validity,
Right.
which they did not. To intervene in the agitation is something which, it's the collector's duty and the commissioner's duty, or the government's duty at best, not the Supreme Court. They should not have intervened.
बस सर लेकिन आर्टिकल 19 क्लॉज 1 के तहत पीसफुल असेंबली एक वर्ड है, वो भी तो एक तरीके से हार्म ही है ना सर, अगर वो डिमांड कर रहे हैं तो इस
Right, you're right. But if I'm demanding something and if I'm not creating any public order issue, then there is a difficulty in the demand being. I think excepting one instance where they had come into the city and created a problem. There's lots of debate about that issue also, but fact remains that by and large, farmers continued outside the town and they were peaceful. There was nothing. They were peaceful, but what we found was the spikes were put on the road. Ditches were dug on the roads. So that wasn't very peaceful.
बट सर प्रोटेस्ट इज लाइक अ नॉर्मल थिंग इन इंडिया.
should
एवरीवन
be.
कोई भी एक गुड प्रोटेस्ट कर सकता है अगर वो आप अनलॉफुल ना हो तो. And according to them, they are actually demanding peaceful. They're like saying कि हम peaceful protest ही करेंगे, we will not be violent until the government reacts. And यही हो रहा है कि उन्हें एक तरीके से instigate किया जा रहा है कि वो इस protest को वैसे कर दे, मतलब against करे.
I'm not in a position to confirm this, whether they are being instigated or not. But the whole issue is that the problem that is arising is that they want to come into the city, Delhi. And the government doesn't want them to come into the city of Delhi in the light of the previous instance which had occurred in Red Fort and other places. Now, who's right, who's not right, I do not know. I can't possibly assess unless I know the full facts. But if the farmers are agitating and they do not have an ostensible intent of kind of affecting the public order, then or destruction of property, government property, public property, then there's no difficulty in the agitation being. I've grown up so many times, the meetings used to be opposition meetings, and even certain NGOs, etc. were holding meetings in Lal Killa Maidan and the other places where you have Ram Leela.
Right.
So no one objected to all that. Why should there be? Protest is my right to free speech and expression. It can be.
But there should be a line between that permissible criticism and hate speech.
But the line is for those who are trying to agitate, for them to draw. Now, there will always be a possibility and a chance of people kind of breaking that line. And so that will always happen.
So permissible criticism जो मैं एक word use कर रही हूँ and hate speech, दोनों का थोड़ा सा minor difference अगर आप बता सके तो.
Permissible speech and hate speech.
Permissible criticism.
Criticism.
Yes.
No, again, you see, the permissible criticism means any criticism which is within the framework of law. Now, and of course, social environment and things like that. But hate speech is a speech which generally tends to create a villain out of something. And it tries to excite and incite people to all kinds of violence. Possibilities are there. So therefore, a speech which is a hate speech Anti-national, see, we have been too frequently utilizing these phrases like anti-national. I mean, assuming for the sake of
What
argument,
do politicians do mostly?
how does it matter if it is anti-national? Supposing I am a person who believes in not using this kind of a terminology of anti-nationalism. Supposing I'm a person who goes to any kind of a crossing and there I stand up and chant certain things that are anti-national. How does it matter? I mean, anti-national is a word which is a much wider, has a much wider framework. And therefore, where a person makes a speech, incites people, and as a consequence of which people get incited and they commit acts of violence, one can understand that. That's an extreme case, which should not be. But then criticizing government or criticizing national policies or criticizing, I mean, some foreign country for its acts in other places of the world, that can't be termed as anti-national.
Okay. And so like Article 19 Clause 2 के तहत जो एक reasonable restriction जो to protect the sovereignty and integrity of the nation के लिए करा गया है, लेकिन ग्लोबल वर्ल्ड में ये सब्जेक्टिव है आपके अकॉर्डिंग, जहाँ पे क्रॉस बॉर्डर कम्युनिकेशन इज वेरी मच कॉमन?
देखिए, अगर आप नेशनल पेरिफेरी में देखेंगे तो इट हैज़ अ डिफरेंट मीनिंग. अगर आप जियोपॉलिटिकल पेरिफेरी में देखेंगे तो इट certainly has a different meaning. In a geopolitical periphery, I don't think anti-nationalism has any importance. Because obviously, if there is a bigger power, it will keep on intervening. No one can do anything about it. That's what we are seeing in Ukraine, we are seeing in Israel. They're the American backing, they're the Russians fighting. So who's going to intervene? So law can only be enforced if there is some third authority which is more powerful, which is not there. So in the international global scenario, this really doesn't have any existence or doesn't happen. In the national scene, only the anti-national aspect, which is a recent phenomena, I would say, because the claim of anti-national activity, anti-national speech, hate speech, and so on, sedition and all these things have been, which have been coming up recently. It wasn't there in the early stages. There I feel that stretching the entire definition of anti-nationalism. Anti-nationalism is a much bigger thing. It must involve inciting to violence, and of course at the same time, it must actually have the tendency to cause law and order, public order problems. Not just like any act. But hate speech has another aspect which we should not forget, and that is the communal violence. So any hate speech which is likely to attract communal violence has to be restricted.
Okay. And sir, if we talk about the digital India, like अभी सब कुछ digitally हो चुका है, so there should be a reasonable restriction on like digital platform, online platform, social media.
Just keep this in mind that there will always be reasonable restriction on every activity. Can be. Otherwise, there is no governance. And if there is no reasonable restriction, then there is no governance.
So when
need for governance.
So फिर वो restrictions तब कहाँ गई थी जब ये आर्टिकल जैसा केस हुआ था and उसकी वीडियोस बिल्कुल वायरल हो चुकी थी सोशल मीडिया पे?
मैं दूसरी बात कह रहा हूँ ना. देखिए, we are talking on a legal plane. Legal plane, the issue is that there will always be governance. The government of India has been created under the constitution. State governments are under the constitution. The constitutional entities. So governance, the sphere of governance will always be there for them. And which is, of course, Article 19, as you said, 20, 21, 22, these are all articles which do permit the government to govern to a reasonable extent. So that governance will always be there. But then governance does not mean that you should write roughshod over the freedoms which the people have. And there, as I said, in extreme cases where, of course, there's incitement to public order issues, incitement to violence on communal issues, which a hate speeches attract, anti-national feelings where obviously you excite some kind of a large-scale fight against the government or overthrow of the government. I mean, it's close to what we call sedition. It shouldn't be just about any observation made on a crossing by any person, like, I mean, criticizing the government or criticizing the institutions of India or criticizing the leaders of India and maybe even India. What's wrong with that? It should be. After all, criticism makes you improve. It should be permitted. If I criticize India for what it has not done, what is wrong with that?
तो बट सर लेकिन आपको लगता है कि आर्टिकल 19 एंड आर्टिकल 21 एक साथ इंटरेक्ट कैसे करता है? इवन कभी ऐसा भी होता है कि फ्रीडम एक्सप्रेशन से शायद ही किसी की डिग्निटी एंड पर्सनल रेपुटेशन भी हार्म हो जाती है, माइट बी।
होती है, ये तो होगा ही, ये एबरेशंस होंगे, बिकॉज यू जस्ट लॉ एंड द कॉन्स्टिट्यूशन कैन नॉट प्रोवाइड फॉर जस्ट एवरी एस्पेक्ट ऑफ द थिंग. As I said, the silence is there and people do take advantage of that silence in law.
So आर्टिकल 19 को एक तरीके से आर्टिकल 19 एक तरीके से 21 का वायलेशन भी तो है?
नहीं, that's not the right way of reading the Constitution. Constitution has to be read holistically. That is, the various provisions of the Constitution which throw light on each other and also throw light on the spheres which each article and its clauses attract. So you can't read one part of the Constitution in a manner that nullifies the other part. You can't do that. The Constitution is an organic whole. So Article 19 and 21, they have to be seen in a more reconciliatory manner. And even if there appears to be any kind of a conflict, you have to harmonize it. And by harmonizing, what you apparently find is, broadly, that Article 19 specifies the species of rights, like speech, expression, association, mobility, and freedom to trade, business, carry on business and all. Now, 21 guarantees liberty, except in accordance with law. Again, except in accordance with law, obviously mean reasonable restriction, not arbitrary or unfair restriction. So Article 21 should include, in my understanding, certain rights which are not expressly specified by 19. For instance, Article 19 doesn't specify right to education. Now, where do you get it? Earlier it was read into Article 21, but then now the Constitution has been amended, 21A. So that's how you read 21 and 19, harmonize the two. One species contains, one set of articles contain, Article 19 contain the personal liberties of individuals, both citizens and non-citizens. And 21 contains overall liberty minus something that is covered by 19. Because it's already covered by 19, why do you have to go to 21? So 21 will always contain something which is not there in 19.
तो जैसे आपने बताया कि कॉन्स्टिट्यूशन में जो कॉन्स्टिट्यूशन के सर मेरे अकॉर्डिंग इंटरप्रिटेशंस ही अलग अलग है, अलग है। इवन द जजेस जितने डिफरेंट जजेस भी अगर कॉन्स्टिट्यूशनल बेंच पे बैठे, उनके भी लॉ को लेकर इंटरप्रिटेशंस अलग होते हैं।
हो सकते हैं, तभी डिफरेंस ऑफ ओपिनियन होती है, बट बाय एंड लार्ज जज नोज द नॉर्मल प्रिंसिपल्स ऑफ इंटरप्रिटेशन ऑफ स्टैट्यूट एंड द कॉन्स्टिट्यूशन. सो it would not be widely divergent in most of the cases. Some cases it may be, but not in all. For instance, what is minority?
Famous landmark cases like ऐसे जो हुए हैं जिनमें
भी case minority judgment means you are not agreeing with the majority.
तब मोस्टली लाइक रेशियो ही इसमें मुझे जहाँ तक लगता है जजेस के, सीनियर जजेस की बात मानी जाती है, दैट्स वाई. लेकिन उससे भी फिर एक तरीके से इंटरप्रिटेशन तो चेंज नहीं होते ना. एवरी जज इज हैविंग अ डिफरेंट इंटरप्रिटेशन ऑफ लॉ.
देखिए, आपका इंटरप्रिटेशन, लेट्स exemplify it in a different way. In the normal practice, when you see something happening or when you observe something, your interpretation of that thing would be A. My interpretation of that very thing may be A plus 1 or A minus 1 or B, whatever it is. It could be different, widely different. So each individual judge has come up from his own particular environment. He's grown up differently, he's practiced differently. And even though most of the legal framework is the same for everyone, but then he has seen that in a different way. It's not like a mathematical formula. Science, one can say that, predict that it has to be precise and everyone has to toe the same line. but not in law. That's the richness of the law. And it changes with your understanding of the whole thing, and your understanding is based on your upbringing.
Okay. So, sir, one thing I want to ask you, like in Article 21, judiciary कैसे reconcile करती है like right to die with dignity, जिसमें Common Cause versus Union of India 2018 का केस था, लेकिन ये एक तरीके से prohibition भी है suicide के law का.
Yeah, every restriction is a restriction on the right.
Right to die sir, with dignity, like ये एक था जिसमें, लेकिन
Please remember, a child is born. He may be born to you or to someone else, but then the child is actually that of the state. You can't, once the child is born, and till his death, until after his death, I would say, you can't say that the ultimate control of the human being is not resting with the state. It is with the state. But after all, what is state? State is nothing but human beings combined living in a country. This is just the state. And therefore, a state must act in human interest, in the public interest. That's what actually it means. The entire concept of reasonable restriction is the public interest part. Again, humans come in public interest. So, a child is born. Now, we had this huge, area where people were indulging in infanticide. The state had to intervene. Now, the parents can always say, it's my right to give birth and not to give birth. Why should state intervene?
there should be there's a reasonable restrictions. Yeah.
So, it's a prohibition.
Okay.
Prohibition to some, any restriction is a limitation on your right. You must understand that. Any restriction imposed by the state is a limitation on your right.
So a person,
Likewise in death.
a person in India can take his life from his, like it has
No,
been
he
mentioned.
can't. He can't, because if you allow that, please see the consequence of that. We are seeing in a rarefied atmosphere that no, people are reasonable, they would not kill themselves, or no one will kill. But fact remains that if you go to the rural areas or in the smaller towns, the incidents of infanticide, in incidents of old people being killed would be huge. The old man becomes expensive to kill him. So that can't be. There has to be a restriction, limitation. And state may prove to be wrong at times.
So the right to die with dignity can never be considered in Article 21.
No, right to die with dignity is very much part of Article 21, and I don't think any court says that you cannot die with dignity. You have a right to die with dignity, and state cannot take away that right. But to die with dignity means what? Is it the force of someone making you die, or someone killing you
The force of
directly,
killing,
indirectly?
huh.
So that's not dying with dignity then.
Abetment and murder is different, and it's like sometimes.
No, take a simple case where people do prompt people to commit suicide. Then that is prohibited.
Mostly it's happening in marital cases right now.
Yeah. So it is prohibited. Then you can always turn around and say it's against my right. But then, see, you have to see the entire circumstances. Law is not logic. Please remember, all law is not logic. Law is primarily experience.
Okay.
So whatever the experience, government builds upon that, and that's all experimental. Today, government may find that this is the need of the hour. Tomorrow, government may change it because it may find that that need has been subserved or that was wrong. It can change it. But please always remember that one cannot have a right to die. Because then what you're saying is that I can commit suicide. If I am a jilted lover, I may jump into a river. I have a right to die. And I have a right to die with dignity. I mean, where does dignity come in here?
No, there should be like a particular norms that how a person can die with the dignity. Like something, I don't know, maybe
there
I'm
would
not
be
remembering
lots of-
some injection things or something, if you can explain it.
No. See, those are things, injection things or killing by hanging and all. These are things.
The killing by hanging is just like a judicial hanging. It's a death penalty given by
I
the
thought
government.
it's crude.
Yeah.
It's crude, but Nowadays, the case of death by hanging are very rare. But it shouldn't be a cult. It should be a little more. You're right there. It should be a little more dignified in the sense, as they do it in the West, by injections and all.
By injections, I guess by giving electric shocks also, and
Not by electric shock. I think
so
it's
some
not.
like of the Chinese.
That will be
places.
torture.
It's a torture only. It's a torture only. It's electrosuction kind of things there, and sometimes gunshots also in America.
No, I do the gunshot. The government doesn't kill like that. I know government. I think.
But sir,
doesn't.
so many lawyers are even against of that judicial hanging because hanging is like
I am one of them. I'm not in favor of hanging. After all, what do you achieve by that? And if you say deterrent, it's hardly a deterrent. We see killings every day, murders every day.
so
It's
in the
hardly
replacement of
deterrent.
judicial hanging, according to you, what should be there?
Judicial hanging in case of a crime. That's
In
what
case
you
of
mean.
criming, yes.
So why should they be hanging first and foremost? According to me, let the person serve throughout his life in the jail. If it is very gruesome, if you feel that it's
Obviously, if
not
we will
possible
talk
to
about
relieve,
some famous rape cases like Nirbhaya and Arjikar, everyone expects a death penalty only.
but why should
For the
one expect that? A person who is supposing who has committed a rape and has been convicted, rape and murder both. So death sentence is one of the options available. But that by itself does not entitle the courts or the government to kill the person accused. I don't think that's the logical way of doing it. It's all right, let him serve. You can always prescribe a condition that he will not be granted paroles, he will not be granted any kind of release, premature, things like that. All that can be done. But there's another way of looking at it. I mean, the person who has committed a heinous crime, and they could be of various nature. The law permits a person to be released after 14 years, actual incarceration. And if he has served 14 years of jail and his conduct during his incarceration has been found to be absolutely all right, and after testing being done and all kinds of examination being done by the police and the establishment, and they find that the person has changed, improved, why should he not be released? How is he different from the person who may have committed 15 murders? And yet he can be considered. Law doesn't distinguish. See, section 400 something, 432, 433, they do not in any manner distinguish between the nature of the crime. It is for the discretion by and large the courts to decide whether he should be given that kind of a release, early release or remission. And if the courts feel that it is not a case which requires that, then the court can say that he should not be released on remission.
I'm going to talk about like custodial torture, which accused suffer. ये भी तो सर आर्टिकल 21 का ही वायलेशन है.
Definitely, there is no doubt about it.
सर इस पे फिर सेफगार्ड्स कुछ नहीं है गवर्नमेंट की साइड से?
है safeguards, but मतलब custodial
Torture, right?
torture is something which is prohibited by law.
But
Any torture.
it's happening. It's happening.
No, it's happening, but
Yeah.
that is for the government to prevent it. Law does not permit it. Law prohibits it. It's equally a crime and as punishable. I mean, it's punishable like any other offense under IPC. So far as law is concerned, there is no inadequacy in that. Now, the government not prohibiting it or government indulging in it, on the other hand, you find governments do indulge in that. That perhaps is unconstitutional. There's no doubt about it.
It's unconstitutional still.
100%.
Okay, so if like a custodial torture is happening to an accused, so what steps should he have?
Accused can always tell the court. Accused can always
Who listens
rake
to
up
an
the issue.
accused?
No, see, what is the actual application of law is one thing. The law permits, law gives you the right, you can always rake up the issue. There's no difficulty. You can rake up the issue, it may not fructify initially, but it may in the long run fructify. It certainly will be taken care of. I don't think our courts would be ignoring that fact. If the accused comes in and says, I've been tortured, any kind of, for instance, confessions before the police have been prohibited. Why? Because Courts know. I mean, the law was conscious of the fact, right from the British period, that the police will do that. And therefore, they said any confession before the police is irrelevant.
Okay.
That's one of the reasons for that.
Alright.
So any kind of torture, whether it is custodial
sir-
torture or otherwise, it's absolutely prohibited.
No, this is sometimes so custodial torture also can cause like death of an accused.
So that's again a crime.
That's
At best, what you can call it is a crime. It's a heinous crime because state is indulging in it. State means the officials of the state are indulging in it, with maybe active connivance of the higher-ups, but it is state with doing it. That's the worst thing. I mean, under our constitutional scheme, this kind of thing is totally impermissible, forbidden. And state is doing it, which means state is acting absolutely unconstitutionally.
All right. So lastly, I want to ask you, just because it's a very important matter regarding the women. Article 21. क्या सर एक मैरिटल रेप के केसेस में सर आर्टिकल 21 कहाँ जाता है? फिर अगर राइट टू पर्सनल लाइफ एंड लिबर्टी की बात होती है तो फिर एक
Marital rape is a rape.
हु कंसीडर्स इट सर कि इस पे बात हो कहाँ रही है?
नहीं.
इस पे तो मैटर्स ही हमेशा आगे बढ़ जाते हैं. लाइक मैरिटल रेप इज नॉट कंसीडर्ड इन एज अ रेप इन इंडिया.
We are confusing two things. Legally, it is. So there is no inadequacy in law
But
or
sir,
the
it's a
statute.
violation of personal life and liberty.
Definitely, there's no doubt about that. Fact remains that if there is a rape, marital rape, one can always go to the police station or to the magistrate. In case police doesn't listen to it, you can go to the magistrate.
Where
straight up.
police consider it in a cruelty, no?
You're right. No, it is marital rape. It's the highest form of cruelty.
Yeah.
You can't possibly have other view. So you can always rake up this issue before the police. Police doesn't listen, then you can go to the magistrate under the CRPC.
But
There's
lastly, a person
provision.
should have to go to the court only.
Magistrate is the court, not the executive magistrate, the judicial magistrate who will direct the police to lodge an FIR and investigate. There's a provision in the CRPC.
But sir, according to you, एक law तो उस पे बननी चाहिए ना सर, because एक तरीके से ये भी तो personal life and liberty को ही harm कर रहा
बन
है.
सकता है. To that extent, I certainly agree with you that there is a whole lot of an area which is shrouded in kind of doubts and mysteries, where mentally, say, we are not ready to accept that concept of marital rape. And it would be a better way if the legislature intervenes and passes a law defining marital rape and then making it punishable.
Okay.
There's no difficulty. Yes, absolutely agree.
All right. So thank you so much. I think this is a very important discussion and first time constitution पे मुझे like इतना clear discussion मिला हो.
Yeah. Thank you so much.
And thank you so much for giving us your time. Seriously. Thank you.
I have all the time in the world.
Thank you so much, sir. That's so great of you.